Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about recent changes in adjudication of I-751 petition, or petition to remove condition from residency. As you're probably aware, if your marriage to a U.S. citizen is less than 2 years old at the time your adjustment of status application is granted, or at the time you receive the immigrant visa, you will receive only a conditional residence, and in 2 years you and your spouse will have to file for removal of that condition, or perhaps you will have to do it by yourself depending on the situation. And in the past, very often after you file this petition, the petition will be pending for a year, sometimes even over a year, and very often the couple will be called for an interview again. Now interview in connection with the removal of the condition from the residency. And some people believe it's a Stokes interview. It's not a Stokes interview, even though it's a second interview. It's a regular interview. Couple will be together in the same room, but the questions might be more detailed, and of course it's simply stressful to go for the interview. So recently what happened is the USICS announced that it will try to avoid calling as many people for the interview in connection with I-751 petition, which is great news, because I believe this procedure of calling everybody for the interview was the culprit, was the cause why those I-751 petitions were pending for so long. And even they were pending for so long that USICS even started prolonging the conditional residency after you file petition, not for a year but for 18 months, because it would take so long for this form to be resolved. So now, hopefully, if everything is done correctly, you will not be called for that interview. So here I would like to provide some tips on how to avoid to be called for the interview in connection with I-751 joint petition. And we're talking about joint petition, meaning that you're still married and you still have a valid marriage and it's a viable marriage, meaning that it's an active, you guys are living together, you're not separated. It's very important. First of all, you need to produce joint tax returns. Many people, for whatever reason, they file separate tax returns, and it's a big mistake, because you cannot claim that you live separately for the purposes of federal tax law, and at the same time you say that you live together for the purposes of immigration federal law. So whatever you're trying to save money for, it's not worth it, and you really should, if you live together, you really should file a joint tax return. Okay, that's number one. Number two, common or joint bank account and bills, utility bills, very important, and there have to be plenty of those bills, preferably for the entire time when you guys are living together. It's very important. And sometimes you will file evidence that you already submitted with your initial filing, and it's okay, as long as you supplement those evidence with the new documents. So tax returns, bank account statements from a bank account, and bills. Life insurance, health insurance policies. Now, common mistake: people have children. A woman was using Medicaid, then she continues using Medicaid. Please do not do that, especially nowadays, because that issue of public benefits now is a hot issue. You do not want to have your residency jeopardized because you are using public benefits in the form of the Medicaid. It's very important. Pictures together, right? I meet people, they say, well, we do not like taking pictures together. We're not like that. Well, and they don't care. All right, you live together, you should have pictures together, because you know that you're going through immigration process, and it's important to have a memory of everything that you do together, because the burden is on you to prove that you live together, not on the government to disprove that you don't live together. So remember that. Affidavits from friends and family are very helpful as well, if they're done correctly. If it's an affidavit, it has to be notarized, meaning that the person has to sign and have their signature notarized in front of the notary, or it can be a declaration under federal law in a special form where the person attests that he or she, under the penalties for perjury, speaks the truth in this declaration. Very, very important. Timely filing documents is very important. To file everything timely, meaning within 90 days of the second anniversary of your conditional residence, as stated on your card. Now, sometimes the date on the card is incorrect. It's very important to know that. And in this particular situation, you should explain that the date is incorrect in your filing. For example, there are mistakes. November can be printed as January and things like that. There was a whole bunch of incorrectly issued conditional residence green cards that were done last year, and USICS was recalling them. So it's nevertheless your obligation to file everything timely based on timeline of your events. Okay, if you received approval of your conditional residency in January, and doesn't matter what states on the card, you should be filing within 90 days of the second anniversary from that January. Remember that. In my experience, usually if you submit that evidence and you explain what's happening with you guys, if you move together somewhere, or if you live together for whatever reason, live separately for whatever reason. Let's say one of you is going to school or does a job somewhere where it's not in the same state we used to be before. You have to explain that. It's very important, okay? And hopefully this will help you to avoid that second interview and avoid delays in the process. And you can learn more about removal of the condition from your green card on our website, www.shautsova.com. Thank you.